now Sam is going to read you the Riot Act.
Our sovereign lord the king chargeth and commandeth all persons, being assembled, immediately to disperse themselves, and peaceably to depart to their habitations or to their lawful business, upon pains contained in the act made in the first year of King George, for preventing tumults and riotous assemblies. God save the king.
And with that, welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, May 8th, 2024. And as you may have guessed, we're going to have a bit of a riotous theme on today's show. That's because we're going to hear about a case from the Seventh Circuit concerning the Anti-Riot Act. Now, that reading you just had from my colleague Sam Gedge, who is our go-to voice for all things old-timey on the Bound by Oath podcast, that was from the Riot Act, which was an actual act. So when you say, I'm going to read you the Riot Act, that was an actual piece of legislation passed in the first year of King George I, so I think 1715. And the expression, I'm going to read you the Riot Act, comes from that, because to stop a riot, you would actually read the words that Sam just read to you. I don't know if it worked very well. I kind of think it didn't from my read of the history. But in any case, that's the Riot Act. Now, years later, Congress passed the Anti-Riot Act. I have no idea if there were a lot of Riot Act jokes when they passed this law, but they did, the Anti-Riot Act. Now, devoted listeners may remember long time ago, one of the first shows that I hosted, we had a reading of the Riot Act, which I read. It was not as well read as Sam. And we talked about a case from the Fourth Circuit that found the Anti-Riot Act to be unconstitutional under the First Amendment. There was another case I think we might even talked about after that, and now it's been a few years, and now we're back. And now my colleague Kirby Thomas West is here to tell us about this case from the Seventh Circuit, which has upheld the Anti-Riot Act. So we have a riotous split on the Anti-Riot Act, and who knows what might happen with that. So with that being said, Sam and Kirby, welcome. Sam is going to have a qualified immunity case for us later in the show, which also has, I guess, a little bit of a riot in it. So welcome to you both.
Thanks, Anthony.
Thank you very much, Anthony. Although I will say, it's really hard to be invited on a day where I have to follow a truly impossible act to follow with Sam's reading of the Riot Act. So I'm happy to be here, though, starting at a disadvantage.
Maybe you can read us part of the Anti-Riot Act with a similar, Georgian accent.
Well, I think since the Anti-Riot Act is from 1968, the effect will be less profound. But I am happy to start this case on the Anti-Riot Act by talking about what the Anti-Riot Act does say. So there is a federal law, as I mentioned, passed in 1968, that says whoever travels in interstate commerce or foreign commerce or uses any facility of interstate or foreign commerce, including but not limited to mail, telegraph, telephone, radio, or television, with intent to incite a riot, to organize, promote, encourage, participate in, or carry on a riot, or to commit any act of violence in furtherance of a riot, or to aid or abet any person in inciting or participating in or carrying on a riot, and during the course of any such of those activities performs or attempts to perform any other overt act for any purpose specified in those subsections, shall be fined or imprisoned not more than 5 years or both.
It's like poetry.
It really is, just rolls right off the tongue. And so the Anti-Riot Act comes up in this Seventh Circuit case, United States versus Betts, because Mr. Betts posted on Facebook in the summer of 2020 the following, also poetry, all caps, riot at Marketplace Mall, time 3, ... Bring friends and family, posters, bricks, book bags, etc. After the mall, we hitting the whole Prospect and Neal, 2 road names. I find this entertaining, perhaps perversely, but I just think it has a nice vibe, right? Like, bring your friends and family, bring your kids and your bricks in your backpacks. We're having a good time. The next day, just after 3 o'clock, 50 to 75 people showed up and rioted, and they targeted 73 businesses where they caused $2.2 million in damage and stolen property. They looted those businesses. Mr. Betts went on Facebook Live to broadcast this looting of the businesses as he described the riot that he was participating in and the property damage that he was committing. Afterwards, he texted his family and friends, bragging about having instigated this riot and caused this property damage. Word of advice, so not formal legal advice. If you do plan on committing crimes, usually best not to announce on Facebook that you intend to commit those crimes, broadcast those crimes live, and then later brag about committing those crimes.
Yeah, I'm going to leave that out myself.
As setting that aside, Mr. Betts was convicted under the Anti-Riot Act that I just read, and he was sentenced to 4 years in prison and ordered to pay about $1.7 million under the Mandatory Victims Restitution Act. And the questions before the Seventh Circuit were, one, is the Anti-Riot Act unconstitutional? Does it violate the First Amendment? And two, was the sentencing that was applied to Mr. Betts and the sentencing guideline, there is no express sentencing guideline for the Anti-Riot Act, so they applied an analogous provision. Was that appropriate? And was the amount that he was ordered to pay in restitution appropriate under the Mandatory Victims Restitution Act? The court, I'll spend less time on those two latter questions. If you're very interested in the applicable, sentencing guidelines or the intricacies of the Mandatory Victims Restitution Act, I commend that to your reading. But we'll focus on the First Amendment holding of the Seventh Circuit. And what Mr. Betts argued is that the Anti-Riot Act is facially overbroad. That is, that it prohibits a substantial amount of protected speech. So as loyal Short Circuit listeners will likely know, the First Amendment doesn't protect everything, right? It doesn't protect speech that is inciting imminent lawless action and is likely to induce that lawless action. And that's under a very famous case called Brandenburg versus Ohio. And what Mr. Betts argued is that this is not like that speech in Brandenburg. There's no imminence here, right? Under the plain language of the Anti-Riot Act, the speech that you engage in can be way before the actual riot, so maybe not inciting imminent lawless action, and it can be kind of attenuated to it, not directly inciting it. He also argued that some of the phrases in the Anti-Riot Act, organize, promote, encourage, are too broad and bring in a lot of protected speech, and that an exception that's specifically listed in the Anti-Riot Act as kind of, I think, trying to preserve the constitutionality as the statute was written, it says that the act shall not be deemed to mean mere oral or written advocacy of ideas or expression of belief not involving advocacy of any act or acts of violence or assertion of the rightness of or the right to commit any such acts or other acts. And he argued that that means that advocacy of certain things like violence or saying that it's okay to commit violence actually does count as a violation of the Anti-Riot Act, and that that is clearly protected speech that shouldn't be swept into under the law. The Seventh Circuit was not writing on a blank slate here. There's a case called United States versus Dellinger from 1972, in which the Seventh Circuit took a very narrow reading of the Anti-Riot Act in order to preserve its constitutionality. So they considered a very similar challenge. And what they said is, yes, under certain readings, this might be unconstitutional, but with an overbreadth challenge, we have a duty to try to read the statute narrowly to preserve its constitutionality, and we can do that here. And the way that we do it is that we say that when the statute is talking about these overt acts, what it actually means, though this is not clear from the statute, isn't overt acts that are then later intended to incite a riot or something like that, which could be very broad and involve all kinds of different speech. What it really means is the actual incitement. So kind of trying to read this, imposing the structure of Brandenburg, that incitement requirement, onto the Anti-Riot Act. And it went on to say that the other aspects of the statute that were considered to be too broad, that were argued to be too broad, could similarly be read narrowly. And Anthony, you mentioned the Fourth Circuit case that we've previously covered on Short Circuit, and that comes up here. And then later a Ninth Circuit case that took the same tack as the Fourth Circuit case, where they said the Anti-Riot Act is unconstitutionally overbroad. But what they did was they severed the overbroad portions of the statute. So they said there are parts of the Anti-Riot Act that actually do just describe the kind of incitement language that is not covered and is, detailed in Brandenburg. And that part of the Anti-Riot Act is just fine. We're just going to sever these unconstitutional portions. What the Seventh Circuit here said is maybe that's actually the way to go. It's possible that in another case, they would say that that was right and Dellinger was wrong, this earlier Seventh Circuit case. But here, Mr. Betts clearly engaged in exactly the kind of speech and activity that's covered by the part of the statute that wasn't severed, that part of the statute that the Fourth and Ninth Circuit agreed is actually constitutional. And so this isn't the right case to overrule Dellinger and say that the Anti-Riot Act is unconstitutionally overbroad. So I think, to me, this is kind of a bad facts make bad law case, where it does seem to me like the Fourth Circuit and the Ninth Circuit are absolutely right that the Anti-Riot Act is very, very broad. I think about the summer of 2020, and there was actually a book called In Defense of Looting. A lot of people were kind of quoting that MLK quote, riot is the language of the unheard, I think misquoting it, but still, all of these things that could be an argument that violence is justified and that, there were riots that later happened. Could they have been because of that speech saying that violence is actually okay? And under the plain language of the Anti-Riot Act, that kind of speech would be, covered and could possibly be a violation of the Anti-Riot Act. And I don't agree with those arguments that were made in that book in defense of looting or the kinds of statements that were made during that time, but they're pretty clearly protected expression under the First Amendment. But in a case here where you have a guy who says, hey, I'm going to loot some businesses and I would like you and your family and friends to join me in looting these businesses.
And bring a brick while you're at it.
And bring a brick. And then he went on to actually do that. This isn't a case that's going to result in a win for the First Amendment.
Well, it's hard to. This is not a model client. I would agree with that. Sam, do you have any riotous thoughts about how this issue might develop in the future?
Not really. Beyond reading this opinion and it just confirming to me that I don't entirely understand the entire exercise of severability. This has always been something that has kind of befuddled me. I feel like we're in a safe space. I can admit that to you both. There's a bunch of law review articles about it. I think Richard Fallon has written several articles, which are very good, and I continue to be befuddled. I guess it seems like there's some kind of tension between this whole concept of severability, or at least the nomenclature of severability, with the idea that courts don't go through the statute books and kind of like take a red pen and strike words out of the statute, right? Like that seems to be kind of what we're doing when we talk about severability, and that's just something that courts love to say they don't do. You could see it kind of making sense in the context of federal statutes like this one, right? If you have a federal court of appeals saying like, hey, that sentence or that subpart of the statute violates the Constitution, right? Like that as a practical matter is going to mean that the federal government can't bring those federal prosecutions in federal courts in that circuit, given that kind of quote unquote severability holding. But it has always really kind of been a head scratcher for me when we talk about severability in the overbreadth context, or maybe even other contexts, in challenges to state laws, where you have the federal courts applying some kind of severability analysis in like an overbreadth challenge to a state statute or a municipal ordinance. Because all of what they're saying about kind of, we're narrowly construing this state law or we're severing this part of a state law, it's not actually really binding on the state or the state courts. And so it's always just kind of befuddled me, like, what are we even doing here? when you have federal courts that are just purporting to kind of take a red pen to state statutes in a way that would seem to be a kind of an advisory opinion. Again, it's not really relevant to this case because we're talking about a federal law and we're kind of within the federal silo of a federal statute and the federal courts and the federal prosecutors. But I don't know. It's always confused me. That's kind of where I'm at.
Well, that raises another issue that has been in the news lately, again, of universal injunctions. So if you have a federal court of appeals that upholds an injunction against the state to not enforce, say, that severed part of the law, I don't even know if that would, to tell you the truth, I don't know if that usually would be part of the injunction. But if there's an injunction that's beyond just the plaintiffs, which we call a universal injunction, then that would bind the state. But otherwise, yeah, that precedent is not, it's advisory, but it's not mandatory on the state courts in a state prosecution, which is always kind of part of public interest law that people outside the system kind of forget about, which is why universal injunctions are often a really good thing. But, that's a different show. But if it's severable, I don't know, if you sever it, it might not be part of the injunction. So then it's kind of like even more, what are we doing here, man? I guess.
Indeed. I mean, on your universal injunction point, we don't need to go down a rabbit hole, I suppose. But I mean, it seems like once you get up to the Court of Appeals or the Supreme Court, right, like the importance of whether you're talking about an injunction that's, plaintiff specific or goes beyond the plaintiff, like the importance of it seems like it kind of falls away a little bit in a lot of cases, right? Because regardless of whether the injunction is technically binding as to the world at large, if you have a published precedential circuit court decision saying, this statute violates the First Amendment as to, Jeff, that precedential impact is going to have much the same effect as like a binding injunction saying, and you cannot enforce this statute against anybody in the state, right?
Well, yeah, this is another rabbit hole, but I should quickly just address it, that a state prosecutor or a state court system is not bound by that precedent from the federal court of appeals. So they could keep enforcing that law or upholding that law, but often as a practical matter, yeah, they accede to it. Now, in a time of more and more, combativeness and partisanship, you could have more case, and there are cases that I've been a part of where the state courts are just like, that's federal courts, we're going to keep doing it our way.
Yeah, I don't know. I mean, we can move on, but I mean, like it does seem like there are potentially practical costs to those kinds of recalcitrant state actors, right? Because yes, the state courts aren't bound by the federal circuit's holding, but like if you're the follow-on person who's targeted under the statute, you can probably go to federal court and overcome Younger, maybe under the bad faith exception. And then all of a sudden the state is on the hook for escalating Section 1988 fees if they keep violating everyone's rights in a way that's foreclosed by circuit precedent. But we're like several steps removed, I think, from why you actually invited us on here. So, well,
and it's not a Sam Gedge show without a mention of Younger abstention. So I appreciate that. Kirby, what
can I? Oh, sorry. I was going to say, can I briefly take us down a different rabbit hole on something that's much less serious? So I think the way to solve this problem about the Anti-Riot Act and whether or not it's constitutional, this is my contrarian libertarian take, is that it's actually a clear violation of the Commerce Clause. Like, this is not about the regulation of interstate commerce that you went on Facebook and incited a riot in your own city. And that's my contrarian libertarian take on the Anti-Riot Act. Under case law, I'm wrong, but under the appropriate,
yeah, I would agree with you. But also here, like this is interesting that and I wanted to talk about this. So this is passed in 1968. It says telegraph in the act, which is just kind of funny. Mail, telephone, radio, or television. But then it also says including but not limited to. So that does seem to probably include using the internet. But the internet, Facebook, I mean, that was routed through probably California servers when this person was talking to their his friends and neighbors, in Illinois. So could you say he was using the channels of interstate commerce and it's actually not, that crazy a thing to say it's covered by the Commerce Clause?
I think that that's certainly true under the modern understanding of the Commerce Clause. Like, obviously, there's no legitimate Commerce Clause challenge to the Anti-Riot Act under all of the case law that we're dealing with. But I actually think under like the plain constitutional text, and you're looking at the substance of the Anti-Riot Act, I don't think that this is a law that's necessary and proper to the regulation of commerce. When the focus of the law isn't on like the use of it's not on.
Well, it's definitely not
how
commerce.
The individual is right. Exactly. It's not
destroying commerce.
Right. Yes, I don't. I think under a kind of a plain text reading of the Constitution, I don't think this would be contemplated within that power of Congress.
So another question for you, having thought about this case more than Sam and I, the practical effect of either this case or the Fourth Circuit case, where the really out there language, is found to be severed. Is it, as a practical matter, it doesn't seem to me to maybe have that much of a consequence, because I just looked up that older case, the 2020 case, and that was actually about white supremacists going to the Unite the Right rally, the infamous one in Charlottesville, where there was a bit of a riot, and there was someone was killed, of course, and in the end, that person wasn't saved. So it seems like with the severing, this kind of remains a tool that is probably usually going to be used in a way that people actually are, legitimately causing harm and aren't going to be saved by the Brandenburg test.
I think that's right, because I think that, like I said, as the Seventh Circuit is trying to do here, and it's kind of reading, atextual to some degree reading of the statute, severing that language, I think has the same effect, where it's basically saying like, okay, this is about incitement. We know about incitement as courts, and incitement is what Brandenburg says incitement is. And so what we're going to say is that that's what the statute actually says. And when you get rid of this problematic kind of overbroad language that the Fourth and Ninth Circuits severed, I think that is kind of what you're left with. I do think, as you mentioned at the top, Anthony, this has now created a bit of a circuit split on this broad language and whether or not it should be severed. And I could see this being something that could go up to the court potentially, particularly because the Anti-Riot Act has been in the news a lot in the past several years. Obviously, this case focuses on the riots from 2020 and the protests of that summer and all of that. But it also has come up in the January 6th hullabaloo. And many of the January 6th defendants have been charged under the Anti-Riot Act. So I don't think this is the last word on the Anti-Riot Act.
Definitely. It reminds me too, and also with looking at the actual Riot Act, the English statute, that riots, there's this crazy history of riots. If you go back to American Revolution and before that, I was looking up something about the Riot Act, and the Bristol riots of 1831 were a big deal, apparently.
Ooh, go on. Tell us more about that.
After the failure of the first Reform Bill in the 1830s, then a couple of years later, they actually did pass the Reform Bill, the famous Reform Bill. But definitely always bad to have a riot, but they are thick part of history, and dealing with them, I think, is a thick part of history. And that's why this is not the last we've heard of the Anti-Riot Act.
I'm a little bit disappointed that you didn't kind of take us down the Peterloo massacre of, what was it, 1819, Anthony? That seems like that'd be...
Well, that's why I have you on.
Okay, well, that's all I know about it, and I might have gotten the date wrong, so... Right.
Well, next time. But for this time, we're now going to the Fifth Circuit, and this is pretty crazy case. And you're gonna have some fun with the facts, listeners, hearing about these facts. But it also just shows, I think, the bottom line of this case is everyone thinks that these defendants should not get qualified immunity, these police officers. So everyone's agreed on that. All the judges are agreed on that. And yet the fact that this case went on appeal on qualified immunity, spent oodles and oodles of time and probably money for the lawyers to litigate this, shows how qualified immunity can be a massive problem, even when there's no qualified immunity. So, Sam, tell us about this interesting story late one night in Texas.
Yeah, absolutely, Anthony. I think this is probably the circuit court decision kind of du jour or of the week. But this is the Good Samaritan case out of the Fifth Circuit. It's been making the rounds over the past few days. But yeah, we can walk through some of the facts, or at least the alleged facts, because years into the case, we're still at the pleading stage. So we'll take all the pleadings as true, Anthony. So Austin Hughes.
If we must.
Yes. Austin Hughes is a former police officer. He's working as an Uber driver in Houston. It's 2:30 in the morning. He's driving a couple of his Uber passengers along a highway, and he sees a pickup truck that's swerving from side to side. It's hitting the concrete barriers on both sides of the highway, which is quite an accomplishment. It's kind of seeing generally kind of poor behavior from the pickup driver. Mr. Hughes suspects that the driver, in fact, is drunk, so he calls 911. And while he's on the call, the pickup just comes to a stop on the highway, which is some more kind of poor behavior. So Hughes pulls up behind it. The pickup driver is obviously drunk, says Hughes. So Hughes takes the guy's keys and his license and the bottles of alcohol that are in the pickup truck, at which point the guy starts running into traffic. And Mr. Hughes then pulls out a pair of handcuffs, which he has, he says, because he's a former cop. He subdues the guy. At which point, two of Houston's finest show up. It's been about 17 minutes since the initial 911 call. These two police officers arrive, and they interview Mr. Hughes. They interview the driver of the pickup truck. And Mr. Hughes explains what happened, and he has documentation of his Uber trip, and there's the recorded 911 call. And then there's another 911 call from a different witness who basically confirms everything that Mr. Hughes was saying. And so meanwhile, you have the pickup driver who's also getting interviewed, and he fails the field sobriety test on every possible metric. And then he launches into this incoherent account of the events. And the way that the pickup driver tells it, he and Austin Hughes, in fact, were friends. And they were drinking at a flea market at 2:30 in the morning, at which point they were driving home together when Mr. Hughes accused the pickup guy of having relations with Mr. Hughes's wife. At which point Mr. Hughes pulls over the pickup truck and assaults the guy and claims to be a police officer.
And his name is actually Jesse.
So that's one of the problems with the account, Anthony. Yes, the pickup driver's account describes Austin Hughes as Jesse. As you astutely note, Anthony, those are not the same name. Also curious is the idea of a flea market open at 2:30 and possibly serving alcohol. The panel seemed very skeptical of that, and I just don't know. I kind of hope we live in a world where you can go to a flea market at 2:30 and buy alcohol. Yeah.
So do I.
If I had a nickel for every good night I've had at a flea market,
and then, of course, like the other
kind
kind of questionable fact is that if, in fact, Jesse, a.k.a. Austin Hughes, had in fact been driving this guy's pickup truck, then kind of how is Austin Hughes' own car present at the scene? Right. So a lot of questions, but you know what? The cops don't overthink it. You know, they basically say, yeah, this guy's story kind of checks out, this guy being the pickup driver. So they let the visibly drunk driver go, and then they proceed to get a warrant to arrest Mr. Hughes for falsely impersonating a police officer, which is a felony. It's punishable by up to 10 years in prison. I think a minimum of 2 years in prison. They put together a warrant affidavit in which they patch up some of the more obvious problems with the drunken pickup driver's account. And then 2 days later, they go to Mr. Hughes' apartment at 3 in the morning and wake him up and trick him into opening the door and then yank him out in his pajamas and arrest him. And that takes about 3 months for the DA's office to finally dismiss the case. This is a long story, but, we're getting to the end. So Mr. Hughes kind of files this very righteous Fourth Amendment lawsuit against the officers, at which point, as you alluded to, Anthony, they claimed qualified immunity. The district court says absolutely not. And then last week, the Fifth Circuit affirmed in a pretty punchy opinion. The court says, the cops don't get qualified immunity, at least based on the allegations in the complaint, because it's clearly established that you can't lie in your warrant affidavit. And the warrant affidavit here, at least as alleged in the complaint, is chock full of fabrications and material omissions and all other sorts of things that are kind of bad form for police officers to do in their warrant affidavits. So, I think for critics of qualified immunity, which I think you're probably a critic of qualified immunity, Anthony. I don't know about you, Kirby. But for those of us who don't like qualified immunity, This feels like kind of a fun decision, right? The Fifth Circuit uses some pretty spicy language. It criticizes the officers. It criticizes the city of Houston. So it's kind of fun all around. Everyone's having a great time. There's a couple of interesting doctrinal nuggets, which I don't want to kind of belabor too much, but this is a podcast about the law.
We're here for the doctrine, Sam.
Precisely. So I'll flag one.
Specifically your doctrine.
Okay. So the Fifth Circuit says in a footnote, it kind of touches on this issue that we at IJ have sometimes touched on as well. The court makes the point that, one of the tenets of modern qualified immunity is that we're not supposed to define the constitutional right at too high a level of generality. And that's really a go-to move in many cases for kicking civil rights plaintiffs out of court. But the Fifth Circuit makes the point that principle doesn't necessarily have as much traction outside of situations where police officers are having to make split-second decisions when they're in like a car chase, for example. And here the cops weren't conducting a split-second car chase style decision when they violated Mr. Hughes's rights. They're methodically fabricating their paperwork after the fact, potentially over the course of days. And the court makes the point that, some of the leniency that we afford to bureaucrats and police officers in other contexts, maybe that doesn't totally translate to this kind of methodical, premeditated, alleged violation. So that's a point that some of our colleagues at IJ have been urging for some time now. And it's nice to see that the courts are starting to recognize it. I guess the other thing that jumped out to me, which is I think what jumped out to you as well, Anthony, based on your comment at the top of this segment, is that I think at a deeper level, the case really kind of spotlights what we could think of as the asymmetry in the entire qualified immunity exercise, right? Because the premise of qualified immunity is that kind of the specter of liability and the burdens of litigation are just so chilling for police officers or any kind of government official that we need to have this really kind of Baroque system of qualified immunity. And as you alluded to, at every inflection point in the case, officers can appeal the lower court's denial of qualified immunity. You can do it at the motion to dismiss stage, at the MSJ stage, at the trial stage. So here, for example, the Fifth Circuit's involvement in this case is at the motion to dismiss. The officers raised qualified immunity at the earliest possible moment in the case. They lose in the district court. They get this special immediate appeal to the Fifth Circuit. And all of this is in service of the idea that the burdens of even having to litigate these cases are just something we need to be really sensitive to, because we just can't have officers being saddled with these kinds of litigation burdens, which I think kind of loses sight of the corresponding burdens on kind of everybody else in the system, most notably the private citizens like Mr. Hughes, who are the plaintiffs in these kinds of cases, right? Because these two cops, for example, at least according to the complaint, violated Mr. Hughes's rights about 5 years ago. This was back in 2019. The case has been pending in federal court now for just under 3 years. It's been on appeal for a year and a half. And the cops haven't even had to file their answer. We're still at the earliest possible stage of the litigation, which, as you indicated, Anthony, that comes with real costs for ordinary folks like Mr. Hughes, who are just trying to vindicate their constitutional rights, which I don't know, just strikes me as, a kind of notable problem with the current system of qualified immunity. And it wasn't totally obvious to me that the Fifth Circuit really kind of registered that, right? Like it's a really nice opinion to read, but at the very end of it, the panel says it's, quote, amazing. Not just that these officers did the stuff they're alleged to do or to have done, but the panel says it's amazing that the city of Houston continues to defend its officers' conduct. But it's not really that amazing, right? Because we've created this entire legal system that incentivizes them to defend their officers' conduct at every stage in a scorched earth fashion and drag these cases out for years and years. I guess I share the panel's frustration with it, but it's not that surprising because that's the kind of system that the current qualified immunity doctrine invites. So I don't know. I've been talking for a while, Anthony, but those are my takes on the opinion. But I'd welcome your all's thoughts.
Well, Kirby, you've been in some scorched earth battles involving these issues.
Yeah, I don't think it's going to surprise anybody to learn that I do indeed share both of your feelings on qualified immunity. One thing that I did enjoy, as Sam said, the punchiness of this opinion and the fact that it was a pleasure to read as somebody who fights these battles regularly. Just I think Judge Oldham is a good writer generally, but the way that he talks about the officer's conduct here, a small example, Sam mentioned, they served this warrant, they executed this warrant at 3:00 in the morning. And Judge Oldham has a little aside. He says, the record does not reveal and judicial imagination cannot fathom why officers needed or wanted to execute this arrest warrant at 3 a.m. And the opinion has a lot of that. And I think it's an entertaining to read, but it is also just nice to see a court taking violations very, I mean, obviously the writing is not, somber, but taking these things very seriously, because in general, to say that courts typically give government actors the benefit of the doubt is just a vast, vast understatement. Courts will often bend over backwards to try to justify unjustifiable conduct by government actors. And so seeing the contrary here, where the court is really saying over and over again throughout this opinion, what you did was inexcusable, and you have put this person through an ordeal for no reason, and you it's such an indictment on this conduct, which was so inexcusable. And I think as a public interest lawyer, it's very satisfying to read, but I imagine even more so for the plaintiff here, who has been going through this absolute nightmare. And what truly devastating experience where you're trying to do the right thing, and you are doing the right thing at great risk of personal cost to yourself. He could have been hit by a car on the road. He could have prevented potentially, not only the death of somebody by a drunk driver, but also this guy's death. He was trying to wander out into a highway while intoxicated. And he did that by putting himself at risk. And then to have the weight of the government come down on you and threaten you with years in prison for doing the right thing. I mean, just truly devastating. So I think seeing a court talk about this in the terms that an ordinary person who hears this story would talk about it. And I agree. I think, Sam, you're right that they say it's amazing is a little bit silly, because it's certainly not amazing to anybody who's familiar with these cases. But this is the way that somebody who just hears this story would react, right? Like, no, that's not possible. Not in the United States of America. But unfortunately, it is possible. But it's nice to see a court have that kind of human reaction to the facts here.
Yeah, I think, although this is, of course, an incredibly entertaining case, there is a lot going on this case than the run-of-the-mill qualified immunity opinion. And I say that because of it seems like this is another part of a project that Judge Oldham seems to have. I don't know if many other judges are part of it, maybe a few others in the Fifth Circuit, but he, as some dedicated IJ listeners or Short Circuit listeners and IJ supporters know, he wrote the dissent in the Gonzalez opinion, which is now pending at the Supreme Court, on our colleague Sylvia Gonzalez, who was arrested months after she supposedly stole these documents that were her own at a city council meeting while she's a city councilor. And he made the point there about this not being a split-second decision, right? This was a premeditated arrest months after the actual act. This thing here is, with the actual arrest was 2 days after this very obvious set of facts had happened, where he did nothing wrong. And there's no dissent, and that isn't like the law, that there's a difference between split-second decisions and something else in qualified immunity, as we often say at IJ. It's just was it clearly established law that something was unconstitutional? But it seems like it's kind of becoming a thing here, thanks in part to what Judge Oldham is saying. Now, you can disagree with that and say, it doesn't matter if it's a split-second decision. That's not what qualified immunity is about. The Constitution's the Constitution. But it does have some kind of common sense to it, which is part of the reason that we do talk about it at IJ. So that seems to be going on here. And Sam, you pointed out that he emphasizes that there doesn't need to be an on-point case like maybe you would need in a split-second decision, because it's just so obvious here. And that easily could have gone the other way. As we talk about short circuit all the time, there's no, often they say you need a case that basically has the same set of facts on point to this one, there's nothing. And he says in his first footnote, rather, it involves a simple, clearly established rule that all officers should know at all times under these couple Supreme Court cases, do not lie. Well, wow, I could bring a lot of litigation with just do not lie and, not have to worry about qualified immunity. I don't think that's going to hold up in other cases, but it's a not just a glimmer of hope. I think it's a beacon of hope that maybe can be used for the future. My big question on this case, though, is what's actually going on here? Because it is so weird that they went and arrested this guy. And I haven't done extensive digging. I haven't gone look in the record or something, but there was a news report at the time that I thought maybe this guy was an old colleague of these officers and this is payback time or something. So they ginned this thing up. But it seems like he was the plaintiff. He was a former police officer, but in Michigan. So he had moved down to Texas, it seems, was Uber driving for whatever reason, but he had this training in his background. So it's unlikely probably that, they knew each other from police officer days. So I wonder what is happening? I mean, it's all speculation. Warning, audience, speculation. But the mind's got to go there. What are they doing here?
Yeah, I was wondering the same thing. And I guess the good news is that now the case gets to go to discovery, and maybe in 3 or 4 years at the next round of qualified immunity appeals, we can have some more insights on what exactly was going on. But on that point, I mean, it seems like one of the other sobering things about this case is that by all accounts in the opinion, this wasn't a high stakes arrest or a high stakes investigation. It was just a run of the mill thing that these officers probably deal with every day. Right. And yet, at least as alleged in the complaint, their incident report and their warrant affidavit are just rife with misstatements and mischaracterizations and fabrications. And it's just if this is what cops do in these seemingly low stakes encounters, I'm sure I'm not telling you guys anything you don't know, but maybe we shouldn't be accepting all of these incident reports and press releases from police departments on faith, as it seems like lots of folks too often do.
Your speculation, Kirby?
Yeah, I could not even begin to guess. I obviously had the same thing as I was going through. I'm like, is there some kind of First Amendment retaliation issue here? Has he filed a complaint about some officers? Sometimes you see things like that, but I couldn't begin to guess.
Yeah, my two thoughts were, one, although citizens arrests are a thing, I got to say, I've never done one. I don't know, although, I've seen, I guess, crimes committed at very low level in my life. Nothing like this, I guess. But I would think that most police officers aren't big fans of citizens arrests. And maybe the fact that this guy didn't just pull the guy out of traffic, but also did the citizen's arrest. And who knows, maybe there was, and someone thought at some point that he really was a police officer, despite what he said, that rubbed these officers the wrong way, kind of like a union turf battle type of thing.
Yeah. And the fact that he had the handcuffs probably contributes to that too. They're probably is this guy out here trying to make citizens arrests? Is he is he out looking for it? Which from the facts as alleged does not at all sound like what's happening. But I think that supports your theory, Anthony, that detail of he was ready for this.
Yeah. So, the mind can only speculate further. And as Sam says, maybe we'll have more news in a few years. Just like maybe we'll have more Anti-Riot Act news in a few years. But for now, we'll leave it there. So thank you both for some Riot Act, Anti-Riot Act, qualified immunity, all in one go. I'm sure we will have more of that another time. But for now, I hope that all of you get engaged.